Welcome to the Italy and Taiwan Exchange podcast, produced by the Taiwanese Chamber of Commerce in Italy. I'm your host, Joe Chang. Here you will hear from entrepreneurs, business leaders, and government representatives who share their insights, experience, and lesson about working across these two countries. If you are exploring new opportunities in Europe, finding local partners, or expanding your business footprint to Italy, you are in the right place. Let's get started with today's Italy and Taiwan Exchange Talk. When Taiwanese companies expand to Europe, legal and cultural differences can be even more challenging than language. So today I'm joined by attorney Marco Maseschi, who is licensed both in Taiwan and Italy and has helped many Taiwanese companies navigate the complex legal landscape here in Italy. Hi, Marco. Thanks for joining us today.
Hello, thank you very much. Thank you very much for inviting me to this conversation.
It's a pleasure to have you here because I know you've been familiar with Taiwan and Italy, and also you've been in Taiwan for almost 30 years. Is that right?
My first trip to Taiwan was 1993. And then since then, I fall in love with Taiwan. I have many friends, so we started to go quite regularly, once a year for the first few years. And then the last 10, 15 years, I went more frequently. My two children studied some years in Taipei, a small company. I taught some years at university. Many friends. For me, Taiwan is really my second home. I'm sorry I don't speak the English.
Yes, I think earlier you told me that you spend almost like 2-3 months every year in Taiwan. So it's really, like your second home. So I would like to start talk about the culture sides first. So because so many misunderstandings in business actually begin here. So from your experience, do you notice any recurring misunderstanding or differences in expectations between Taiwanese and Italian business, especially when it comes to contracts, negotiation, or partnership communications?
Partly, it was true many years ago that the language was a barrier. Now, especially Taiwanese or Chinese, many they speak good English. So it's also in Italy, more and more people are more familiar. Companies who deal internationally, they are familiar with English. So I wouldn't consider any longer the language as a barrier. I tell you, I work also with Japanese companies. And I tell you that for a Japanese, the cultural shock is stronger. For Taiwanese, definitely there are differences. Having had many years of experience in Taiwan, the society, the cultural way is more soft, let's say, in the sense that during the negotiation, you are less direct in Asia generally. In Italy, you can be sometimes harsh in the reactions or direct in certain judgments or saying, you can say immediately no. In Asia, the no is always very soft masqueraded, From the point of view of negotiation, I would say that legally speaking, in reality, I don't see so many differences between Italy and Taiwan. Legislation is based mostly on the German law, as a civil law country. It's like Italy or France. So the basic contractual principle, the basic principles for the contractual are very similar. Unfortunately, the difference is when you enter into the court system. The court system in Italy is unfortunately, it's still very slow. If you end up, into a litigation, it's generally speaking, unless it is strictly necessary, I always advise clients to try and avoid any litigation, to find a possible settlement, to reduce some requests, but to find a settlement rather than going through the courts.
Yes. So I'm curious that from your experience working with Taiwanese companies, and I assume they have some sort of a relationship or doing business with Italy. Right. So what are the common, probably legal or cultural aspects that often overlooked? And maybe since that seems minor at first, but later turn out to have a big impact on business operations or partnership.
The thing that is penalized Italy is unfortunately, in some cases, a reputation. So when I speak with many Asian companies, Italy is seen as the very difficult countries compared to other European countries. It's seen as a bad guy in the room. In reality, without entering into specific figures, we don't want to enter into details. I sent you some screenshots from data that I discovered. I took it from the web, and labor cost, for instance, the hourly labor cost in Italy are much lower than Germany, France, and many other countries. So it's not true that Italy is generally more expensive, or in terms of difficulties, for example. Employment law or labor protection in Italy definitely stronger than what could be in Taiwan, but is very similar or even weaker than other Northern European countries. So if you look at the labor protections in case of dismissals that workers have in France or Germany, the union involvement, the union powers in these countries is not different. In some cases is worse than Italy. So Italy is affected by this reputation that is bringing from some years ago when the market was more convoluted, more difficult. Right now, I wouldn't see make big difference. So even for legislation, people should understand that definitely European Union is not a country. It's not like United States. So you're not talking about a federal state. You're talking about 20 plus different states with their own legislation. And many legislation are actually implementation of EU directives or regulations. So the basic principles, they may change from one country to the other, but the European legislation has influenced more and more the local legislation of each country. So they don't expect much difference. Then some big differences are still in taxation. Taxation rates, different countries they are not able, or VAT, for example, may vary from one country to the other quite sharply. But all other rules are very, very similar because the principles are driven by the European Union.
So you think that Taiwanese companies shouldn't be scared about the employment law when coming to Italy, or in terms of the labor cost? Actually, it's quite competitive in Euro markets. And in terms of regulation,
you go in countries that recently joined the European Union. I'm talking about Romania, Bulgaria, this country, where initially labor costs are much lower still now. But year by year, they're increasing. It's like in China or Taiwan 30 years ago, the labor costs or social security charges, they're much lower because the country was expanding. Okay, the economy was still growing a lot. The most advanced European countries, you see that the tax rates, labor costs in Italy, I told you, if you can read or find a way to tell your audience the summary chart that I sent you by email in the beginning of the conversation, you will see very attractive. So employment protection, I remember, I can give you an example. I have a small company in Taiwan and initially hired a Taiwanese employee. So for 1 year, contract 1 year, and then they told me that the standard, you give a 1 month bonus. Then each month the salary was 1,000 and I paid 20% social security charges. Every month was very fixed. In Italy or other countries, you have to take into account of many variations, how many holidays, the holiday of holidays, how many paid permits. So the salary and social security charges are always different. Not one single month they pay the same salary and social security charges. I found it, for me, was very easy. In Taiwan, where I spoke with my accountant at the beginning of the relationship, and she told me, Marco, you have to pay within this day every month this amount to the employee and this amount to the social security. That's all. Clear, In Europe, it's different.
Yeah, so people probably have this assumption in terms of those market like Asia or East Europe has more competitive labor market, but in reality, that competitive advantage may not be as good as the past.
But like in any other situation, you can save some cost establishing your company, let's say in Bulgaria, Romania, these countries where all costs are lower, but you have some disadvantages in terms of logistics, in terms of finding highly skilled workers, technology. There is always a downside in choosing one place. So unless you have a specific reason for being exactly in one country, it is true that European Union principle is a freedom of movement of goods. People are, and all your audience know that once you bring your goods in one European country, you no longer pay custom taxes from one country to the other. So you can have a warehouse in Bulgaria and ship everything from Bulgaria to any other country without any additional charges. If you intend to have a subsidiary or company aside where you do some manufacturing, for example, most manufacturing, even what is apparently simple manufacturing, you rely on the high technology, on to be closer to subcontractors, to suppliers. So all these are criteria which are taken into account by companies when they select a place where to establish themselves.
You've made a good point regarding geographic location.
It is for a more important investment, not only the Italian government, also the local regional government may grant a lot of facilitation and subsidies. I know that recently a high-tech company from Taiwan established a large manufacturing site in Novara, for example.
Yes.
It was announced, and this was in participation with the help of the regional government and of the national government. So this kind of project, you can definitely have some lot of support. Especially in the last few years, our government is very, very active in trying to attract foreign investments.
Yes. So do you find this challenge, like in terms of employment, in terms of the legal systems, when the company is coming into Italy, the challenge that they face, are they different by the company size, whether it's for a startup, SME, or a large enterprise like the company you just mentioned, like they set up factories here?
Yes, Italy labor laws have a big strict division. For companies with employees up to 15 employees, you have different rules, especially with a reform that was implemented in 2015. You can now dismiss an employee by paying a severance payment, which is based on the seniority of the employee on the company. So you don't have to have a justified reason. The problem is not the problem. The big division is that for companies bigger than with more than 15 employees, different rules apply. So the employee, in case of dismissal, can also be asked to be reinstated, brought back to work by the judge if the dismissal is considered without grounds or for discriminatory reasons, for example. So what happens is that very often you end up in an initial litigation and you find a settlement, because it is quite standard for the employees who are fired, unless you find a preliminary agreement. It's quite standard to file a claim with a lawyer to threaten a legal action, knowing that many companies want to avoid litigation cost and uncertainty. So they always budget some money to try and avoid litigation. Because labor courts in Italy, we say, are not always often tend to decide in favor of employees.
Yeah, I think for most of European countries, they seem to be like that. Yes, the way they operate is around the employee, not towards the customers.
Employee protection is quite, but again, it's France, Germany, most countries is similar.
You say the dividing line is 15 employees.
That's why they say, I'm reading it, so that's why in Italy there are so many small companies. Because unless you reach a certain level where you definitely need to grow farther and farther, many companies try to avoid to exceed this limit, whereby if you exceed 15 employees, you have different rules. You have to appoint a union representative. It becomes more complicated, let me say. So many companies, again, unless there's a specific need, or sometimes they create 2 or 3 companies which are in some ways, belonging to the same owners or groups, just to avoid because exceeding the 15 employees.
I see. So any company is staff above 15 employees, it doesn't matter whether they are 30 or 300, 3,000, they all have to follow the same rule.
Some level, if you exceed then 50, there are even more different rules. But the basic distinction is the 15.
Yeah, the 15 is where for the micro, small company, where they have more flexibility to operate. And so in terms of the common legal challenge, I don't know, for Taiwanese company coming to Italy, do you have any example that you can share with us in terms of legal issue that maybe they face and then they have to seek for a legal route to resolve it?
Yeah, some debt recovery is very difficult, very long. So I know that This is common for almost 40 years experience. It's common for every one of us. You start dealing with someone, with a company, you trust them for years and years, and they start telling, okay, send me one shipment of this time, I'll pay after 1 month. You've been working for 20 years, you give them trust, and then you end up after 1 year where your credit grows higher, and they end up going bankrupt.
You mean for the Italian company?
Yes, yeah. What happens is that initially, for the first few years, companies are more cautious. So they say, okay, I'll ship with a letter of credit. If you receive the letter of credit, I'll ship the goods. But then after one company, you start to be a more reliable, customer, you give them some trust. And then what happens, this is not only in Italy, you end up after some years, if the company has some financial troubles, and I tell you, in this case, you are an unsecured creditor. You have these many bankruptcy rules in many countries. You have secure creditors. We are given priority, like banks, tax agency, the social security agency. In case of a bankruptcy of a company, they are given priority on whatever funds are collected back from the bankruptcy. And all the unsecured creditors, all the others, share in equal parts whatever is left. But generally, very little or zero is left.
Yeah, so you say that debt recovery is quite difficult, almost impossible, if you try to do that from a different country.
Then the company is already losing money. Frankly, I did not many cases because I don't like to charge clients knowing that it will take 2-3 years. I tell you, my experience, only big companies start the procedure really because they must do it for compliance reasons.
Yes.
To put the debt into a bad debt in their financials, if they are listed in the stock market, for example, they must show to the auditors that they have done their best to recover. So they, knowing that it's going to be almost impossible to recover the money, but they still start the procedure just because it's for the local laws or the local accounting rules, they must do it.
So is there a difference? I mean, if they have a physical presence in Italy, and it will be easier to recover that, they are registered locally?
No, not really.
Okay. So in this case, usually
there are some documentary requirements, from Taiwan, you have to perhaps, but with the power of attorney, you have to start a litigation. Companies, just a matter for someone from Taiwan to sign a power of attorney and legalize a data in office. One of the officers come to Italy and sign in front of me, and that's all.
So it's quite important for company to do the background or credit check. And because, as you said, it's very difficult to recover the debt.
Credit check is doable. Italy has a good system at the company's house. The registering place is called. When a company is registered, it files all the registration papers, the bylaws, everything. But then in the certificate that you get the name of the directors, the name of the auditors, and then any further changes is recorded, as well as companies must file every year their financials, the approved financials, at the company's house, and everything is public. These information are easily retrievable by anyone. So the problem is that it's not it's updated, but if you close your financials on December 31st, 2025, the fiscal year, you must approve the financials within 4 months by the end of April. Sometimes they give you a 2-month extensions. Then you file it. And then you find they are readable or extractable by third party after 6 or 7 months, for example. And then the financials, are not always the exact. I don't mean they are cooked, how they say in the United States, or they are not real, but they don't reflect the actual financial situations, or I don't know how reliable are credit agencies which they do the credit review, So it's, you can also through that now, if you make a good search on the web, you can find also a lot of information about gossip or rumors or spreading something that's not official, but you can understand something about a company business or possible financial trouble in a financial situation.
So it's more about doing the due diligence before you do business with the other parties. So I assume in a very unfortunate situation, that's probably the last option to go with a legal route.
Not the common, but this I tell you after all my white hairs, It's very common also for lawyers. What you do is that often in negotiation, you want to be smooth. The negotiation for the sales agents coming from Taiwan, in reality, not only Taiwanese, in many situations, they are afraid to discontent or displease the other party, so they don't enter into much details or asking too many information,
Right. I think that happens.
Yeah. It's like negotiating a contract. Sometimes you avoid discussing specific points in a contract because you want to close it. You are more focusing on the price and the
Correct.
Discounts and so on, and you don't focus on other legal things, which may be later critical for the relationship,
Yes, this is especially probably for SME because large enterprise usually involve internal legal counsel.
Medium, most likely they have an owner, single owner, and can take a decision yes or no in 5 minutes. It's more in bigger companies. It's more difficult because for bigger contracts you have to go through a review of you have a legal department, CEO, you have a board of directors, so it can be everything more scrutinized, more controlled. Now companies, the owners are like the other guy say, okay, let's sign an agreement, 2 pages, and do business.
Yes, I think you also mentioned that in terms of coming for the legal help, sometimes it's not just to resolve the disputes, but also I think your role is help company to negotiate, help both company to find a common ground that they both can accept the conditions. And do you have any example that you could share with us? Some memorable case?
Memorable case with Taiwan? No, I do. Some arbitration in China. That was fun because it was 25 years ago to arbitration in China. Generally speaking, yeah, they ended up well, I tell you. Despite the difficulty it was in English, it was 2 out of 3 arbitrators were Chinese, but that was the key point because I appointed, the Chinese party appointed an Italian arbitrator. So they expected me to appoint an Italian arbitrator as well, while with the help of a Taiwanese lawyer, one of my friends, I chose a Chinese arbitrator. Didn't expect this. And the Chinese arbitrator I chose was not in favor of me, but was very neutral and very respected, very serious professor. So we were able to do the arbitration in a neutral way. Effectively, you're looking at the proof in the right way. So it was fun. Nights and nights preparing all the documents on. And then for Taiwanese companies, some larger transaction I cannot mention the names or even the kind of transaction, but I have some companies to do the last 10 years. Good investments, they've been expanding well in Italy.
Yes.
So they're happy about the Italian investments, I will tell you.
And so those cases that you involved, at the end, they able to settle or whatever, come to agreement. Do you think what was the most key important factors that helped to bridge that?
End up in court, generally the claimant, let's say I was acting for Taiwanese company, but not only Taiwanese, any company is fatigued, is tired after some years. They don't see the results. Everything is moving so slowly, and this forced them to accept a settlement that at the beginning they didn't accept. In my opinion, the best would be, varies from case to case, but you must take into account the years of litigation. If you see that the other party is not financially in good health, so they don't have anything to lose. The party is a company which doesn't have enough money, so they don't have anything to lose. The best will be, even at the beginning, to accept a strong reduction of your claim and say, "Listen, okay, I know that this deal was a bad deal. Give me 50%, we close everything, and we close everything instead of spending money on legal fees and headaches, because you know that the next hearing is scheduled next year. So we go from year to year in next hearings."
So I think the key takeaway from here is really the due diligence carefully at beginning.
To avoid exceeding a certain exposure.
Use the risk.
Yeah, so in practical terms, you cannot expect the other party, if you are selling, to pay each time upon delivery. Okay, this is not the real world. So there always must be a degree of, okay, at the beginning you can do a letter of credit, you are very stable and so on. But otherwise, I mean, especially if you have a subsidiary in Italy. So internationally it's quite standard. Say, I do the shipment, FOB, I received the letter of credit, truths are checked, I have a letter of credit, I'm guaranteed. If you have a local company, never accept, so you deal B2B in Italy between the two Italian companies, even though the Italian companies that Taiwan is controlled, you must give a degree of credit. So pay the 30 days after invoice, 60 days after invoice, you know. But then there must be a limit. So you can't give too much credit to the other party. So they start delaying the payments or are requesting too much. You must be careful.
Those examples are especially applicable to the relationship between customer, supplier, this kind of relationship. And I wonder if, for example, sometimes the company coming here, they're looking for partnerships. They are collaborating or whatever joint venture. For this kind of engagement in terms of the contract or what to look for, is there any tips that you could share with us or any things for Taiwanese company particularly should look out, or even for Italian company to look out when having this sort of a partnership between the Taiwan and Italy?
Yeah. Joint venture, you know, it's a very nice concept. I was taught 25 years ago a story, which is in very cases is very true. One day, a pork and a chicken, they meet and the chicken say, okay, why don't we do a joint venture? Wow, eggs and bacon are so popular, we can sell it anywhere in the world. So they started joint venture 50-50. After a few weeks, pig went to speak to the chicken and said, listen, we have to stop the joint venture. Why? I mean, we are so successful. Look at the sales. We are selling anywhere in the world. And the pig said, come on, it's a 50-50 joint venture. Each time you put an egg, but I put a slice. So if it's going to continue like that, I'm going to die. And the chicken answered, you know, the philosophy of a 50-50 joint venture is that one of the partners must die.
Okay. Is that advising is not the ideal partnership in terms of
I don't want to discourage you, but you start with a 50-50 because you want to avoid the conflict discussion. You say, I don't want to say to the other party, I want the majority. So many parties say, okay, let's start 50-50. But then a different philosophy, different business strategy, you know, different perspective is very difficult for. So you can do it, but in a joint venture agreement, it must be very clear breakup clause. So what happens if something, I mean, if just we start disputing, if we are in disagreement about certain choices, where to invest, for example. I don't want this to discourage people, but to be warn them that you may end up in continuous litigation or endless litigation to close the joint venture, because when you have a 50-50, you are up in a situation where no one can take decision. Because if I vote yes and you vote no for any decisions, you know.
Yeah, I think that's a very good point, because I never thought about that, but I guess it's almost like entering into a marriage. A lot of a couple, you need to sign a prenuptial agreement. So you sort of determine if you separate later, then how you're going to park different ways. And I guess to have that pre-agreement and then before you tie the knot, I think it's important.
It would be to find to have a local strong partner where you say you keep the 70% instead of having a fully controlled subsidiary. You find an agreement with a 30% strong partners, Italian partners, which can help you in running the company, in expanding the business, knows the local market, the local customers. This is definitely helpful. You maintain the control, put limitation in the contract, you give him some guarantees, but you keep the control of the joint venture.
So in your experience, you see more successful cases in terms of this kind of partnership where the local Italian companies and have the majority of the shares and then with.
I'm acting for the Taiwanese. I will insist if they can that they keep this majority. Cases I've seen that in exchange, some Italian companies accepted this deal because it was a way also for them to expand and becoming part of a larger group. Taiwanese have a strong presence in many Asian countries. Taiwanese companies were the first to re-enter China when they open the market. I know several Taiwanese companies that they move their factories and still have their factories there in China. Now they're switching, they're moving to Vietnam or Burma or other countries also. China became too expensive, but they have this touch knowledge, not only of the market, of the possibility that Far East Asia offers. And so for an Italian company to have a partner which has opened them the opportunity, especially if you're a small company, that you would not have the capability and the financial background, the financial back to do it by yourself, create a lot of opportunities.
That's a really good example of how partnerships can be mutually beneficial. They combine strengths from two very different markets. And this kind of partnership can create real growth opportunities.
Okay, one last question before we wrap up. So as we know, international trade plays a really important role in Taiwan's economy. So when it comes to cross-border business, especially e-commerce, what are some of the key legal aspects that Taiwanese companies should pay attention to when selling or operating in Italy?
I'm not sure about Taiwanese, but in Europe, consumers' protection is very strong, especially when you do electronic contracts. So you must be careful. I mean, you cannot do it. Shipping from abroad now is doable. From the logistics, it's doable. But what many companies, they do, they have a warehouse in Europe, and they ship from within Europe. But in terms of return, in terms of warranties that you have to do in products, for example. But I know that many Taiwanese companies already are very, very familiar with this rule. For example, CE trademark, in the certification that confirms that the product is in compliance with European rules, for example. So before shipping any products into the EU, you must be sure to get these certifications. Definitely, I didn't have time, the figures. Compared to Northern European countries, electronic commerce market share in Italy is still, compared to UK or Germany, Northern Europe, is still lower, but it's expanding substantially. That's causing, you have probably read about the fact that in the last few years, due to COVID, this expansion of electronic commerce, many small shops are closing down. And many small activities have closed because many people, the new generations, are used to do their shopping of everything. I see my daughter, they don't go out in the shop to buy shoes, they order online. My daughter's boyfriend is Taiwanese.
You have a very strong tie with Taiwan, both a son and daughter. Like you said,
I was checking some numbers earlier. E-commerce in Italy still has a lot of room to grow compared to those matured markets in US or UK. So for Taiwanese companies, it's a great time to explore this market. It's not yet so saturated. And it's also important to understand how things work here, especially the legal side of operating and trading online in Italy.
In Taiwan, most likely, I was reading there is a consumer code, protection code also in Taiwan, so the return policy. I think there is not much big difference, between EU rules and Taiwan rules about this. Taiwan is, in many aspects, a very, very well advanced, also from the legal point of view, country. So, as I told you, the basic legislation is similar to the civil law. Countries are countries which are legislation based on the Napoleon Code and the Roman laws, and Taiwan laws are based mostly on the German laws, similar to Italian and France.
Thank you, Marco, for walking us through these complex but very practical topics. Today, we covered employment, debt recovery, partnership, and cross-border e-commerce. So these are real situations that companies often face,
or things that they might overlook when they do business abroad in Italy.
So thank you so much for sharing this valuable insight, and thank you to all our listeners for tuning in.
Thank you.
If you enjoyed today's episode, don't forget to like and subscribe to our podcast. If there are any topics or industries you would like us to cover in the future, feel free to leave a comment. We would love to hear your thoughts. Thanks for listening, and we will see you in the next episode.